the folks that weren't living in Putnam County. I'm just struggling to understand how they fall within the statute of temporary absence. You've got one person that is living and working in, I think it was St. Johns County, whose relative worked at the supervisor of elections, and because that person wanted to vote in Putnam County, that was okay with the supervisor of elections. Two other people had moved from the state, had no residence in Putnam County, had no intention of, at least at that point, of moving back to Putnam County, and that's okay with the supervisor of elections. Why don't you explain why that falls within temporary? I mean, under your theory, if I go somewhere, let's say I'm working in Daytona, and I'm living in Daytona, but listen, I spent almost 20 years on the bench in Orange County, and I really want to vote for some of the judges and the sheriffs over there, but I'm living here, I'm working here. I have no plans to go back, but because I want to vote for the races in Orange County, I get to do that under your theory.
Yes, Your Honor, that's something that the trial court spent a lot of time addressing in the order. And the two people that you mentioned who are living out of state, Mr. and Mrs. Ivey, there was a lot of concern at the supervisor's office about whether these folks should be able to validly vote in Putnam County. And emails were exchanged between the supervisor's office and Tallahassee to determine if these people could meet the statutory definition.
But that's not Tallahassee's call. That's the supervisor of elections' call.
Yes, Your Honor, and all of the...
Tallahassee says, well, maybe they're, Tallahassee is giving the exception to the general rule that you have to be a resident of the county where you're going to vote, because there is an exception. The exception is if you're temporarily absent from the county. For instance, people who go, kids who go to college, or people who are working out of state temporarily. There are a lot of different exceptions, but these people had no intention of, there wasn't anything temporary. They had moved. They were permanently gone, and could they come back? Sure. Of course, anybody can move. Who knows what's going to happen in the future? But there was certainly no intent at the time of this election for them to come back, or for the one voter who lived and worked in St. John's for him to come back. They were voting in Putnam County because they were longtime residents of Putnam County and they wanted to. That's not what the election system is designed for.
Yes, Your Honor. The interpretation of the election official from Tallahassee, Maria Matthews, was clear that it was appropriate for them to have voted. The Ivies in North Carolina did not vote in any other election. They had ties to Putnam County.
Didn't Ms. Ivey have a North Carolina driver's license?
I believe she did, Your Honor.
And y'all have relied, and I say y'all, the appellees have relied on that opinion from the Division of Elections 16-01, which defines and looks at legal residence, and it has two components. One is an intent to reside. Y'all don't talk about that in your brief as applying to this case. Y'all talk about it as a desire to vote in Putnam County, not an intent to reside in the county. That's apples and oranges, and I don't understand why y'all made that kind of an argument. You cite to that opinion and then ignore the test that it gives you.
Yes, sir. The case law says that the election officials are presumed to make appropriate decisions, and the supervisor of election in this instance appropriately relied on the determination from Tallahassee that these people could have their precinct be the supervisor of elections office in Putnam County, and this was not something that was done in haste. It was thoughtful.
It doesn't matter if it's done in haste, it's clearly wrong. The test that y'all rely on is you have to have an intent to reside, and there has to be some objective evidence that you are treating it as your residence, getting your mail, whatever. And here we have the Ivies. They sold their house. They moved to North Carolina. That's where they live permanently. We know she has a driver's license. I'm not sure that the record shows whether Mr. Ivey had a North Carolina driver's license, but the evidence was overwhelming that they intended to be residents of North Carolina. And under what rule of law can permanent residents of North Carolina vote in Florida, especially in Putnam County? There's nothing in your brief that supports that conclusion, is there?
Your Honor, I can only point to the case law that says that the election officials are presumed to act in accordance with law. That was an appropriate interpretation from Tallahassee to the supervisor's office. And I'm under the 10-minute mark now. If I can just
I'm going
wrap
to
up.
give you a little extra time. Don't worry about it. I'm going to give your co-counsel,
Thank you, Your Honor.
counsel for the other party.
I did. Yes, sir.
I'm going to give him his full time.
Okay, thank you, Your Honor. I did want to circle back around and talk about the perfection and fair comment that Your Honor made earlier, and that really gets to the meat of the coconut, because this election shows that the statutes were done correctly and things were followed appropriately.
I can tell you that at least two of us don't agree.
Okay.
At least two of us, at least as to the three folks that are not living in Putnam County, disagree completely with that.